Good day, ladies and gentlemen. This is Joy Stephen from the Polinsys Studios, and here is some information about the 4 in, 4 out. That is 4 years in, 4 years out for temporary foreign workers in Canada. What are your options? This video is prepared with content support from Rhonda Williams and her article in the Student Herald. Ms. Williams is the Manitoba PNP, the Saskatchewan PNP, and the Work Permit Specialist for Polinsys. This video is produced for Immigration for Me and the Student Herald. As of April 1st, 2015, thousands of temporary foreign workers in Canada will be subject to the so-called 4 in, 4 out rule. Changes made in 2011 to the Temporary Foreign Worker Program by CIC means that once a temporary foreign worker has worked in Canada for 4 years, he or she will not be able to obtain a new work permit until he or she has been outside of Canada for 4 years. After that time, the person may apply for a fresh work permit. There are some exceptions to this rule, which I'm going to talk to you later. The rule will be applied as of April 1st, and many workers and their employers will be affected in the coming months. Some workers will have to leave Canada when their permits expire. While not unexpected, many workers and their employers are looking for options to help them remain in Canada and in their jobs. There are several potential options that could lead to permanent residence in Canada, and I'm going to discuss some of them. Express entry. Under the new Express Entry EE file management system introduced by CIC on January 1st, 2015, some temporary foreign workers affected by 4 in, 4 out may be eligible to apply for permanent residence in Canada. EE is a file management system used by CIC to facilitate the selection of candidates for immigration to Canada under certain economic immigration programs. Let me just rephrase. CIC is Citizenship and Immigration Canada. Now, the economic immigration programs under the Express Entry will be the Federal Skilled Worker Program, or the FSW program, the Canadian Experience Class Program, or the CEC program, the Federal Skilled Trades Program, or the FST program, and some provincial nomination programs, PNPs. Having work experience in Canada can be helpful to your application under Express Entry. If you qualify under any of these programs, you may be eligible for processing under Express Entry. An experienced immigration consultant can help you to create an Express Entry profile and find ways to enhance your ranking in the Express Entry candidate pool. The other program is PNPs. Several provinces in Canada have their own immigration programs. While a portion of some of those programs will now fall under Express Entry, most of the programs don't. Each PNP is specifically designed to meet the needs of a particular province and selects new immigrants with skills and backgrounds that meet those needs. If you're already working for an employer in a province with a PNP, you may be eligible to apply to the PNP with the support of your employer. With so many different programs, it is advisable to carefully research which program might best suit you. Another program is the Quebec program. The province of Quebec has its own points-based immigration program. French language proficiency is not required for the Quebec Skilled Worker Program, although it would certainly be helpful. With your background and work experience in Canada, you may already be eligible for this program. If you have already worked in Quebec for at least 12 months within the past 2 years, you may be eligible for the Quebec Experience Class program. You do not have to prove, you will have to prove at least an intermediate proficiency in French for the Quebec program, for the Quebec CEC program. Keep in mind that PNPs and the Quebec immigration programs have the expectation that successful applicants will reside in their province. You should be mindful of the fact that your intention to reside in the particular province will be carefully considered. And you should be serious about your genuine intention to reside in the province in which you apply. Another possibility is the family class. Since you arrived in Canada, you may have established a genuine family relationship with a spouse or a common law partner. They might be eligible to sponsor you for a permanent residence in Canada. You and your sponsor will have to submit a joint application which will evaluate the spouse for sponsorship and then the relationship for legitimacy. If you take this route to immigration, make sure that you maintain your legal status in Canada if your work permit expires. You may have to apply for a change in status. If you do change your status in Canada to visitor status, remember that you cannot work or study whilst you remain in Canada on a visitor status. International student may be another option. You might decide to upgrade your qualification and remain in Canada as a student on a study permit. It takes a bit of time to apply to educational institutions and get accepted, so make sure you start in advance. If this is going to be a pathway to immigration for you, make sure you know if the particular institution you choose will render you eligible for a postgraduate work permit. Now let's talk about exceptions to 4 in 4 out rule. Now, some of the exceptions are if you're working in NOC type 0, that means if you're in a management position, or in NOC type A, if you're in a professional position, you're exempt. If you're in an LMIA exempt jobs, you're exempt. For example, if you're under international agreements such as NAFTA, you are exempt. If you're under a Canadian interest, visa, you are exempt. If you're on a self-support situation, you are exempt. Or if you're on you're on a visa on humanitarian reasons, you are exempt. Now, applicants under SAWP, that is the Seasonal Agricultural Workers Program, they are exempt from this rule. When no work permit is required for a foreign national to work in Canada, like business visitors or foreign diplomats or performing artists and those working for foreign news companies who are reporting from Canada, they are exempt from this law. Permanent resident applicants who have received a positive selection decision or approval in principle in the PR category for which they have applied, they are exempt. Provincial nominations, applying for an employer-specific work permit who intend to perform, work pursuant to an international agreement between Canada and other countries, other than an agreement, concerning seasonal agricultural worker, they are exempt. Even an agreement entered into one or more countries or on behalf of one of those provinces, they are exempt. We will keep. There are a lot of exceptions to this rule, and we will keep you updated about this section of migrants as and when new options are available. Therefore, please click on the subscribe button below and to be notified of any new video uploads which might come in the near future. Now, from all of us here at the Student Herald and Immigration for You, this is Joy Stephen signing off. Thank you.